to let someone do this stuff.
Okay, so ladies and gentlemen, we are back again, another class. And this class we are talking about still terms and conditions like the last class, but this time around we are talking about conditions and warranties. So can you hear me? Okay, so ladies and gentlemen, so we are back. For those who this is your first time of joining my class, my name is Olayeni Dear Kolola Daniels, popularly known as Dieko Spectre, and welcome to another episode of Dieko Talks Law. On today's episode, like I said earlier, we'll be talking about conditions and warranties. In my last class, I introduced you to terms of a contract and mere representation, and I gave you about 5 rules, 3 given by Chattel, three given by Chisaya and 5 foot rather, and 2 given by Tritel. And these are rules that you are supposed to apply when you want to sever the mere representation from that which is the true term of the contract. And then I told you, okay, if after severance and you see that a term does not fall under term of the contract because it doesn't come under any of the 5 rules, then that term, that particular clause, which is not a term and which is known as a mere representation, can still fall under what is known as collateral contract. Do you understand that? So I told you when you are writing your exams, you should, if you are asked a question on mere representation and term of contract, you must list the 5 rules. Although you tell them that the first 2 rules, is there a problem? Hmm? Is there coin? Just making it echo. Sorry, 1 minute.
Check your mic.
Sorry, 1 minute.
Can you hear us? Adjust the mic.
It's not my mic. I think it's this thing. Is it still echoing? Ask if it's still echoing. Please, guys, is it still echoing? So I will know that everything is okay with my sound before I continue. Is the sound fine?
Yes.
Is it okay now? Is it okay? Okay, good. I can't even remember what I was saying, but I know that I was talking about our last class, and I said something about our last class being about mere representation and terms of contract. And I told you that when you are in your exam, you must write the 5 tests, and then you must point out to them that the first 2 tests are not as relevant because they are being contradicted by the decisions of the court. But the third test by Tritel on special knowledge, the first test by treaty on verification, and the last test, which is the second test by Tritel on degree of importance, you must cite cases on them and show how these are tests that can sever terms of contract from mere representation. And if something is said to be mere representation, then it will still be collateral contract. What's wrong? 1 minute.
Yeah.
1 minute.
Plain back, not a coin. It's plain back.
It's not here, and it's not here. I think it's yeah.
It's what? It's not just plain back.
I can't find the solution to the problem. That's the thing.
Move it. Plain out.
Yeah. Watch it here. Ask them if it's still echoing. Sorry, the comment will show there if it's still echoing. So please, is it still echoing now? I just want to confirm. Please type in the comment section if it's echoing or not. Watch it here. Ask them if it's still echoing. Sorry, the comment will show there if it's still echoing. So please, is it still echoing now? I'm waiting for you guys. Oh, anybody say anything? Please type in the comment section if it's echoing or not.
Yes, it is.
Are you serious?
Yes.
Okay. Now we have a very big problem where I don't even know where the problem is from. I'm waiting for you guys. I'm trying to think. Can't be from a speaker. It's not from the phone. Please, is it still echoing now? Is it still echoing now?
What is not echoing? It's plain back.
Playing back in. Or is it playing back now? Okay, they said no. That's not playing back. So can I continue? Please just write yes, you can continue. I can hear me well.
It's okay. It's okay. It's okay. Trying to listen.
Okay. So if it happens again, I think it would then mean that we have to send another link. But as at now, you can attest to the fact that it's currently going well and I can continue, correct? Is it going well? Can you hear me properly? Okay. So as I was saying, I'm so sorry. You know, when I was sending the link to the group, I told you that guys that there are a lot of factors. Light factor, network factor, now there is microphone factor, and it's playing over. Do you understand? So it's not easy holding a live class of this nature. A lot of things has to be taken into consideration because it's actually not easy. So moving on, now that the microphone factor is out of the way, please let's go on with our class right now. So we already talked about the last class. Everything's perfect, right? We already talked about the last class, and we are moving into conditions and warranties. Last class, like I said, we talked about terms and mere representation. Now that one is out of the way. Now when we've ascertained that something is not a mere representation but is actually a term of a contract, then it falls under 4 categories. The first one, which is the least important, is warranties. Then after that you have innominate or intermediate terms. Then after that you have conditions. Then after that you have fundamental terms. Do you understand? So under terms of contract, there are 4: warranties, innominate or intermediate terms, conditions, and fundamental terms. You know, before that, our first argument was what is going to be regarded as a term of a contract, right? That's the first thing. Is it this clause, is it a term of a contract or is it a warranty? Or is it a mere representation, right? That was the first thing we're arguing about. Now we are now done with that argument, and we know that there are 5 tests to determining which one is which one. Now we then go a step further. Now we have ascertained that something is a term of a contract. We now need to know this thing that is a term of a contract. There is no doubt that is a term. We know it's a term, but is it a warranty, or is it a condition, or is it an innominate, if I'm correct, innominate or intermediate term, or is it a fundamental term? So 4 questions. But in this class, we're answering just 2 questions. Which one? Condition or warranties. The class after this, we answer another question. Is it innominate or intermediate? Yeah, that's one. So that's the 3rd question. Then in next class after that, we answer another question. Is it a fundamental term? Do you understand? So with that, let's now go into the class. What is a condition and what is a warranty? Do not forget that in my last class, I want to give that illustration again. In my last class, I said that there were 2 people. Is the this thing good? Yes. In my last class, I said that there were 2 people, right? A and B, right? And then I said that if we have A and we have B, then A wants to buy cake of 500,000 naira, right? And B was to make the cake for A. That was what I said. And then I said that A wants 3 layers of cake, right? The top should be red velvet, the middle should be chocolate, and then the last should be vanilla, I think. And then A's birthday is 8th of December 2022, and it's going to be 20th birthday. The 7th, a day before my birthday, right? And this is how I want the layer to be, right? Good. The subject matter of what I want again should be cake. So we had 3 things, 3 terms. Number 1, we had the date. Number 2, we have the arrangements, or before the arrangement, the subject matter, which is a cake. And number 3, we have the arrangement of the cake. We know that these are terms, but the question is, right? The question is, in fact, before we determine, we still need to determine if the date is a term, if the subject matter is a term, and if the arrangement is a term. But let's take it for granted that the 3 of them are terms. Now, if the 3 of them are terms, then how then do we determine which one is a condition, which one is a warranty, which one is an innominate term or intermediate term, and which one is a fundamental term? So let's go straight to our note. Now, obligations created by a contract are not all of equal importance, right? Thus, one term may be of major importance whose breach would lead to a discharge of contract, while another term may be a relatively minor one whose breach could result only in damages. So we are beginning to talk about, one will lead to what? A discharge. When you hear a discharge, like I told you in last class, repudiation. So so a discharge is also known as repudiation. Please, 1 minute. Yeah, so as I was saying, so a discharge of a contract is also known as repudiation. Do you understand? That is to do away with the contract. The innocent party saying, I'm no longer interested in this contract. So, you know, if it's a condition, you can discharge and repudiate. If it's a warranty, you can, just ask for damages. That's what we are learning. We are going to learn so far. So accordingly, over a long period of time, various terminologies have been evolved to represent various categories of contractual terms and liabilities. Currently, 4 categories of terms have been identified in the following descending order of importance. Descending means from the lowest in importance to the highest in importance. So when you look at warranties, that's number 1, the lowest. Innominate or intermediate term, the second. Then condition is one of the most important, and the fundamental term. So what we are talking about in this class, like I said, is just condition and warranties. We already know that there are 4 types of terms, right? If it's not a term, then it's a mere representation. If it is not a term of a contract, if the court says that this clause is not a term of the contract, then it's a mere representation. We have 5 tests to determine that, right? But now, we now know that there are 4 types of terms. Do you understand? Conditions, warranties, innominate term or intermediate term, and fundamental term. But in this class, we are talking about 2, conditions and warranties. So let's go into our class on conditions and warranties. The oldest and most common use of these four terms is, now before attempting to describe or define them, that's conditions and warranties, it must be stressed that these terms are used in many different senses and indeed interchangeably on many occasions. Thus, of condition alone, it is said that there are at least 12 different senses in which they could be used. There are 12 different senses in which condition can be used, but in relation to contract law, especially at your level, year 2 in any university in Nigeria or in outside Nigeria, but where you are talking about introduction to contract law, all you need to know about conditions, there are 3 uses. There are 3 uses, and we are going to learn that very soon. According to the statement of James L.J. in Les EXP Collins. Now, there are 3 uses, and these I want you to put the 3 uses. I call them PIS: condition precedent, condition subsequent, and condition inherent. But I prefer to call it PIS. So precedent, inherent, and subsequent. Now I will explain this to you, and you know why I call it PIS. But let's continue. So what did James say? Now before I get to what Lord James has said, I want you to understand, like I said, there are 12 different usage of the word condition, but for your level, all you need as at now is PIS: condition precedent, condition inherent, and condition subsequent. You don't need all the other. Maybe when you are doing your masters in contract law or your PhD in contract law, you can then begin to look at these areas. But right now, know these 3, especially for your contract law exam. So what did James L.J. say in Les EXP Collins? He said that conditions may be precedent, subsequent, or inherent, like I said. So who told us about these 3 PIS? James L.J. So when you're quoting it in the exam, you must quote this guy and what he has said. Need not be word for word, but you should have the element of what he's saying. Conditions may be precedent, subsequent, or inherent. A condition is precedent when, unless it is complied with, the estate does not arise. It is subsequent when, if broken, the estate is defeated. It is inherent when the estate is qualified, restrained, or charged by it. Now, you might not understand what we are talking about or what this guy just said. The grammar is too much. So let's go straight to picking each of them one after the other and explaining them. Now, let's start with condition precedent. Thus, an agreement subject to the preparation of a formal contract, which is an example of condition precedent. An example of condition precedent is where you have an agreement subject to the preparation of a formal contract. Is one subjected to a condition precedent? I will explain that. For that, the agreement is not binding until a formal contract has been drawn up and signed. Thus, there is therefore a condition precedent when the right to obligation under an agreement are suspended until the happening of a stated event. Now, I'm still going to explain to you the whole condition precedent, but I want to use the case of Pine and Campbell. Just give me a minute. Yes. So, when you are talking about condition precedents, this is what we're saying. We're saying that this is it. A contract is about to be made. But before this contract is made, something must be done. Something must precede the contract. Until that thing is done, which precedes the contract, that contract cannot be made. Are you listening? That is why I call it condition precedent. It goes before the I. Inherent, it is in the contract that is to be made. Subsequent, it is to be made after the contract. You understand? But let us start with precedent. So, okay, let me use Pyman and Campbell as an example. So the first authority we are discussing today, in terms of the fact, is the case of Pym, Pym versus Campbell, Campbbell. Now, an agreement by the defendant to buy the plaintiff's invention was made subject to the approval of a third party who is an engineer. It was held that there was no binding agreement until the approval was obtained. Now, let's look at that again. He said an agreement by the defendant to buy the plaintiff's invention was made subject to the approval of an engineer. An agreement to buy the plaintiff's invention is the contract. They contract amongst each other to buy the plaintiff's invention. So that is the contract. But for that contract to come to life, there must be a precedent, and the condition precedent is the fact that there must be an approval by an engineer. Except that engineer gives a go ahead on the P, the C cannot come to life. Do you understand? So unless you have the condition precedent being done first, then the condition, the contract itself cannot come to life. So when you're talking about condition precedent, so you know the first thing that James told us is that condition operates in several ways, but James told us, as Lord James told us, 3 ways: precedent, inherent, subsequent. Let's start with precedent. Precedent means that the condition must be done before a contract can come to life. The contract, the person sued in relation to the buying of the inventory, that you agree that you are going to buy my inventory and stuff like that, and the guy said, yes, I agree that I will buy your inventory, but I said that before that agreement can stand, before this contract can stand, there must be a precedent, and that precedent should be that there has to be an approval from an engineer. In the absence of an approval, it negates this. When this is negated, this is negated. If there is no precedent, there is no contract. For you to have a contract, there must be a precedent. If this is crossed, then this is crossed. Do you understand? What is the case? Pine and Campbell. We also have another case of Pickard and Hines. Pickard and Hines. In the case of Pickard and Hines, let me spell it for you: Pickard versus Hines, Innes. Pickard and Hines. Decided, that's a Ghanaian case, decided by the former full court of Ghana, Cape Town, or Cape Coast rather. The defendant offered to engage the plaintiff as a surveyor, provided his current employer does not object to his leaving. So the guy said, I want to engage your services as a surveyor. Do you understand? So there was offer and there was acceptance. I would also, want to be a surveyor and stuff like that. Offer and acceptance. So there was to be a contract, right? But he made it subject, provided that the surveyor's current employee would not object. So the contract is contract of surveying, right? I want a surveyor and I want to do my surveyor. Okay, I agree to be your surveyor. That is it here. That's the contract. But what is the condition precedent? The condition precedent is that would only happen, the contract would only come to life if you then your employer agrees to it. So if your employer does not agree to it, which negates the condition precedent, then the contract will automatically be negated. Do you understand? Where the condition precedent is negated, the contract is negated. Do you understand? So in this case, the defendant depended upon the goodwill of the plaintiff's current employer. Now, the plaintiff could not obtain, do you see that? The plaintiff could not obtain his current employer's consent to leave and join the defendant, and the latter refused to employ him. So the thing is, the surveyor, he had an employer, right? So the employer said, no, I know they leave you, you must work for me. But he left regardless. He left the firm regardless of the fact that the employer said, I will not work, I don't want you to leave. Do you understand? Then he went to meet the other guy and said, no, regardless of what my employer said, I want to work with you. The guy said, no, I cannot employ you, because although I agreed to employ you earlier, but I agreed subject to the condition that your employer will agree. So now that your employer does not agree, please, I don't want wahala. And then he sued the guy to court and say, now because of you I leave my former employer. It is because of you I left my former employer, and now you don't want to employ me. Why? And then the court had to hold. Was there a condition precedent made subject to the contract? Yes, there was. And it was made clear. Do you understand? So if there is a condition precedent, then if the condition precedent is negated, the contract is negated. You can't have a contract until the condition precedent is available. So on suing the defendant for breach of contract, it was held that his failure to fulfill the condition precedent operated to terminate the defendant's offer. Simple. So under condition precedent, which I just explained, P, we have two cases, Pine versus Campbell and Pickard versus Hines. And then we go to the next case, which is condition subsequent. Do you understand? Condition subsequent. And then we get condition inherent. Do you understand? Condition subsequent. Now, although these are said to occur where the happening of an event operates to destroy an existing obligation, no convincing illustration of this concept has yet been given. The cases cited as illustration on true reflection are examples of condition precedent. Thus, in the much cited case of Head versus Tattersall, Head, H-E-A-D, versus Tattersall, T-A-T-T-E-R-S-A-L, Head and Tattersall. What happened in Head and Tattersall? Now, before we get into what happened in the case, what we are saying is that there has not been a case decided that shows the true reflection of the principle of condition subsequent. And when we are talking about condition subsequent, there is something after the creation of the contract, there is something that has been done to destroy the obligation in the contract. It happened after the creation, do you understand, of the contract, so to say, and all that. But we are going to look at another case. There is an African continental case, but let us start with this case of Head and Tattersall, and let us see if there was something that was used to destroy the obligation of the contract. So in this case, what happened? A horse sold to the defendant was stated to have hunted with Bicester hounds. I think hounds are like dogs or something, like huge dogs. I don't really know, but I know that they are animals. So there are these types of animals that I feel that they want the horse to have hunted with, like moved around with. Do you understand? And then there was an express condition that if the horse was found not to have hunted with the Bicester hounds, it could be returned. And then on finding out that it had not in fact been hunted with the Bicester hounds, the plaintiff returned it. So here we are talking about the plaintiff, right? The plaintiff wanted to buy a horse, and then he made it very clear to the other party that I want a horse that has been hunted, with Bicester hounds. So it's just like saying I want to buy a dog, and I'm saying that I want this dog to have walked about or grown up with let's say German Shepherd for 2 years. I specifically want that. Maybe there are reasons why I want it to my own knowledge, but that is what's happening in this case. He said he wants a horse that has hunted with Bicester hounds, and that if there was an express term made by the other party that if later they realize that he has not been the horse hasn't hunted with Bicester hounds, then they can return the horse. When the plaintiff realized that this horse has not hunted with Bicester hounds, the plaintiff now wanted to return the horse. What happened after the plaintiff did that? He was held entitled to do so, in spite of the fact that in the meantime the horse has sustained injury. The court held that he could do so. Now, the point that we are trying to make in this case, that was an important point of that transaction, right? The fact that he must have hunted with Bicester hounds, and we know that it was a condition, right? Like we know it's a condition upon which he entered into the contract. So it was very important in the contract. But the question is, was he a condition precedent that must have been done before entering into the contract, or was he a condition subsequent? The reason they are calling it a condition subsequent is because he found out after the contract had been concluded, he found out that he had not he had not hunted with Bicester hounds, and because he had not hunted with Bicester hounds, they now repudiated the contract. But then it's my submission that It is not a condition subsequent. It is a condition precedent. Now, why is it a condition precedent? Look at this. What are they looking for here? They are looking for a horse. That's the contract here. But it was stated that for us to have a valid contract to buy a horse from you, then that horse is a precedent. That horse must have hunted with Bicester hounds. That was it was a precedent. I want a horse from you, right? But the kind of horse that I want is such that must have, hunted with Bicester hounds. So that is a condition precedent for me to buy a horse from you. That is not a condition subsequent. But if you look at most English textbook cited by other authors, you will see that this case of head and tattersall is used as a condition subsequent instead of a condition precedent. So I hope you can see why it's a condition precedent, right? Because it was a condition upon which, before this contract can be valid, this one must have existed. For this to be valid, this one must have existed. Let's go to Prime and Campbell. What was the fact of Prime and Campbell? Just for me to refresh. Yes, for me to buy your invention or your inventory, an engineer must approve it. Do you understand? In the absence of the engineer approving it, I will not buy your inventory. If you go to the case of Pickard and Hines, for you to come and work for me as a surveyor, your employer must have agreed. If your employer does not agree, then you cannot come to work for me as a surveyor, right? Then we then come to the case of heads and tattersall, which was used for condition subsequent. But then for me to buy a horse from you, then that horse must have hunted with Bicester hounds. So in the absence of it having hunted with Bicester hounds, I would not work for you. Can you see how it is more of a condition precedent than a condition subsequent? Because condition subsequent is supposed to be here. Do you understand? Not here. It shouldn't go back. It should come front. Do you understand? But let us look at the clauses. So my submission, this is submitted, is not the case of condition subsequent but of condition precedent. The contract was subject to the condition that it had hunted with Bicester hounds. It had not, and so there cannot be a contract. Very good. Now let's go to the unreported case of African Continental Bank versus Okonkwo. African Continental Bank versus Okonkwo. What was the fact of the case? Now, the fact of the case offers the closest illustration so far to a condition subsequent. Is everything all right? How many minutes for the class now?
23.
Okay. 30 what? 33. Okay. Now, offers the closest illustration to a condition subsequent. The defendant had applied to the plaintiff for a loan. Now, I want you to follow this because the fact is quite clumsy. So let us get it. The defendant, so let us use an illustration up here. So we had the defendant applied to the plaintiff for a loan, right? So the subject matter here is a loan, right? So the defendant told the plaintiff that I want a loan from you. During the consideration of this application, the plaintiff invited an estate valuer to value the property which the defendant was offering as security. So he said, oh, you want a loan, right? Oh, no problem. So let me put it here. Let me put it here. So there's a contract, right? This is supposed to be the contract, right? So the contract here is a loan, right? I'll give you money and then later blah blah blah. Now there's precedent here and then a subsequent here, right? Right? Very good. Now we know what the precedent is, right? Unless this is done, this would not be valid, right? Good. And we know what the subsequent is. We will see what the subsequent is very soon. Now, so during the consideration of the application, the plaintiff invited an estate valuer to value the property which the defendant was offering as security. So this plaintiff now decided to call an estate valuer and said, oh, there is this land that the defendant wants to use as security. Go and value the land and let us know. Then the valuer charged 958 naira for his services. That is his money. and this was debited to the defendant's account with his consent. They knew, the defendant knew, right? So when the valuer went to the land, right, and then what is it called? Now note that I want you to know something. They did not, look at this, they did not say that we will give you the money here. They did not say that we will give you the loan unless the valuer's money is paid. I mean, we will not give you the loan or something unless the valuer's money is paid. I want you to know that the context of what we are talking about is the valuer's money. I want you to realize that the bank contracted a valuer and told the valuer to value the defendant's land, and that when he valued the defendant's land, his charge, his own personal charge for his professional duties, was 958 naira, and then they deducted the 958 naira from the defendant's bank with the consent of the defendant. There was no problem. Do you understand? It was not a condition that, oh, we are going to collect your money, blah blah blah. Do you understand? Now let's continue. When subsequently the application for loan was not approved, the defendant refused liability for the valuer's fee. So you know they've already deducted the money from the defendant account. So now you can see the contract here. This is the contract. They now did not approve the loan for him, but they have deducted money, which is subsequently. Do you understand? They are deducted money, and then he is now saying, no, why will you deduct money from my account when you did not give me loan? Now they wanted to know if it was a condition subsequent, and I want you to look at what Akpo Vijay said. And he said that the clear understanding of the parties was that the defendant would pay 958 naira as a cost for the valuation if the loan of 20,000 was approved. It would be unfair to the defendant for him to be made to pay 958 for the valuation of his property against a loan which was never granted. The fact and decision of this case more closely illustrates the concept of condition subsequent, for it could be argued that the subsequent failure of the bank to grant the loan operated to destroy the defendant's earlier obligation to pay for the valuation. Now let's come back so that before you get lost. Now you should know that this is not a prima facie case. A prima facie case is like on all fours condition subsequent, but it is the one that closely represents what we mean when we talk about condition subsequent. So there is a contract, right? There's a contract, and then there was no discussion as to what is it called, the valuation fee being a condition precedent to giving the contract, right? It is after they had had their agreement on this thing that they now called somebody to come and value, and then say, oh, we'll collect it from you. So it came subsequently after the agreement for the contract. Are you listening to me? It operated after the agreement. It did not operate before the creation of the contract. It wasn't that, we will only give you the contract, give you this loan when we have deducted the money from you. Until we deduct the money from you, you will not have the loan. No, that was not how you operated. They had already agreed. Oh, you want a loan, right? Okay, no problem, we'll give you the loan, but we need somebody. So what will be the condition precedent is going to be evaluating the land. We will give you the loan only when your land is up to the value. That is the condition precedent, or could have been read to be the condition precedent. Your land being of value is the condition precedent to granting your loan. So after they've made an agreement that, okay, we're going to have the loan and all that, but that is if your land is up to value. Then after the whole fee, the valuer now finished valuing, then which came subsequently after the contract has been made. Then he deducted the money from the account and stuff. He did not have a problem with it because it came subsequently. And then all of a sudden I said, this one is also cancelled. Give me my money now. Do you understand? So it's a condition that came subsequently. I need you to put it in your head it might not, this area might not come out in exam so much. I don't think that you will find a school asking you what is the difference between condition precedent and condition subsequent and all that, but it's just for you to know. Precedent is such that the contract will not be in existence until that condition is done. Subsequent is such that it is an happening that happened in the future that is operating to destroy the contract. Do you understand? Something that happened in the future that you just say, oh no, destroy the contract. Do you understand? So precedent operates like this, subsequent operate like this. Do you understand? And that's what we need to know for that. And we then go to our next our next topic, which is what we in fact are doing in this class: condition inherent. We are talking about condition inherent. The essence of this class, when we are talking about condition, is condition inherent. This precedent, subsequent, they are just for academic purpose for you to understand. Some universities might decide to test you on it, but I don't think all universities will. But when you're talking about condition, on condition inherent, universities will test you on it. Faculty of law will test you on condition precedence, condition inherent rather. Do you understand? So let's go to this part. Now, the third category of condition listed by James L.J. in Ray Les EXP Collins are condition inherent. That's the third category. Condition which qualify the obligations contained in the contract. So what we are saying is condition inherent in the contracts themselves. So when we are talking about what we are saying here, that you should deliver the cake by 7th is a condition inherent in the contract. I want a cake from you. The subject matter of what I want from you, of what I'm buying from you, is a cake, right? So that is a condition inherent in the contract. Do you understand what I'm saying? It is in the contract. Condition precedent is something that must be done before the contract can come in. Condition subsequent is something that must have been done after to vitiate something in the contract. But condition inherent is the terms of the contract themselves. Do you understand? So that's why this is a type of conditions. This is the type of conditions we are mainly concerned with in our video lectures. Used in this manner, the term condition is a term of contract itself, not external to it, which may be enforced against one or the other parties. The term warranty is also used for the same purpose, and for some time no clear distinction was made between them. However, clarity was brought into the subject matter by the distinction created by section 11 subsection 1b of the English Sales of Goods Act of 1893. And what does it say? Section 11 subsection 1b of the English Sales of Goods Act of 1893 defined conditions as a stipulation in a contract, the breach of which may give rise to the right to repudiate, that's the right to treat the contract as repudiated, or the right to damages, and the warranty as a stipulation, the breach of which will give right to the claim for damages but not the right to reject the goods and treat the contract as repudiated. So we are talking about conditions and warranties, and we are saying that before the advent of the Sales of Goods Act of 1893, they used to use the words interchangeably, and there wasn't a clear distinction between the use of conditions and the use of warranties. But after the English section 11 came into force on the English Sales of Goods Act of 1893, then it became clear conditions can operate to treat a contract as repudiated when that term has been breached. But a warranty does not operate in that manner. A warranty is such that what you seek for is damages if that warranty has been breached, and not necessarily for to repudiate the contract. Do you understand what I'm saying? And how do we know that? Section 11 of the Sales of Goods Act. So when you are speaking on conditions, one of the sections that you must cite must be section 11 sub 1 of Sales of Goods, after citing the James L.J.'s dictum in Ray Les EXP Collins. Now to continue, although it is not defined, although this is not a definition of a condition or warranty respectively, this prescription of remedies for their respective breaches demonstrate that while a condition which attracts the remedies of repudiation and damages must be a major term, a warranty which attracts the remedy of damages must be a minor term. Now, I told you in my last class that when we are talking about each of these terms, one thing we should be looking at, three things. Number one, what is the clause, right? Number two, what is the effect, right? And number three, what is the nature, right? So if the clause is date, right, that you are to give the cake by 7th of December, that's the what, right? So the next thing we have to look at is what is the nature of that, and then after that we look at the effect. Once you've gotten the nature, is it a condition or a warranty, you can automatically know what the effect is. But my problem with the definition of section 11 is that it doesn't tell us what the condition is. It only tells us what the effect of a condition is. What the condition is not telling us, but what will happen if a condition is breached? Oh, you can repudiate. After repudiating, you can claim for damages. It's repudiation or claim for damages. So you can either repudiate alone, or you can both repudiate and claim for damages. But for warranty, what is the warranty? I don't know. But okay, what are the effect of a warranty? Oh, I know that one. You can claim for damages for that one. Do you understand what I'm saying? But what is it? When I'm reading through the terms of a contract, how can I look at a term and know that this term is a condition? How do I know that? You know that when you're reading through a contract, especially when you're even hearing the parties talk, because all we know is Igbo men and the fact that they like money. So let's say an Igbo man is contracting with a Yoruba man, and the Igbo man wants to bring a shipload of something from the Yoruba side, that's the western region, and it's contracting. All their conversations were on phone. Hey, how much? I want get this, I want do that, do you understand? Like, they barely would sit down and be writing contract. So when you hear the both of them talk, how do you sever from what they have said? Oh, okay, when you said this one is a condition. Then, you admitted to this, that one cannot be treated as a condition, that was a warranty. How do you know when you hear people talk and tell you their agreement in a contract? How do you know what is a condition in what they said and what is a warranty? Section 11 doesn't tell us what a condition is and what a warranty is, such that when I listen to people talk or when I read through a document, I can tell you no. Clause 11 of this document is a condition, except where it is stated that this clause will be a condition. Do you understand? So this one makes you a contract law student where you are writing a contract for somebody. Under the terms of the contract, if you know that to your client this particular thing is so serious and it is something essential to the contract, you should write it there that particular clause is a condition, a breach of which will lead to repudiation and damages. Do you understand? I'm just giving you an insight. But when we are talking about, you're not listening to people talk, how do we then determine? But let us go to, is there a problem? Okay, let us go to what section 62, because section 62 seem to want to help us define something. So what is section 62 then defining for us? So this is confirmed by section 62 of the Sales of Goods Act, which describes that a warranty is something that is collateral to the main purpose of the contract. Now, can you see that? It is what? It's collateral. Section 2 of Sales of Goods Act tells us that a warranty is collateral to the purpose, the main purpose of the contract, although there is no equivalent elaboration on the nature of a condition. If you go through the Bill of Sales of Goods Act, you will see that they did not tell us the nature. No, this is what I'm talking about. Nature. When you see something, a clause, how do you know the nature, whether it's a condition or a warranty? They did not tell us what a condition is, but they told us that to know if it's a warranty, ask yourself, is it collateral? Section 62. Is it collateral? So can we say that the date telling B to what's it called, give the cake across to A on the 7th, can we say that is collateral to the main contract? That's number one. Can we say that the cake itself what we want is a cake, and then you brought puff puff, can we say that that is collateral to the main contract? We know we are interpreting this in line with section 62 of the sales of goods. And then when we are talking about the arrangement, red velvet should be up, chocolate should be in the middle, vanilla should be at the end. When we then are talking about the arrangement, if they now put this up, chocolate down, red velvet here, would that be said to be collateral? Are you beginning to understand what I'm saying? So one of the things when you're looking at terms of contracts, first, what is the term we're talking about? What is the clause that we're talking about? Then what is the nature? The sections does not define to us what a condition is, or what but it tells us that what a warranty is something that is collateral. So therefore, in my note I said it would follow that if a warranty is collateral to the main purpose of the contract, a condition must at least be what? Be essential to it. More so because the breach of a condition will result to the repudiation. For the court to go as far as saying, oh, because this has been breached, you can repudiate, it must be something that must be at least essential. Do you understand? Section 82, collateral to the main contract. Right? If he's saying that it's collateral to the main contract and does not tell us what a condition is, the nature of a condition, then at least for the court, for section 11 to have told us that it is such that that's the condition, is such that you can repudiate and even claim for damages, repudiation or and right to claim for damages, right? So not only can you repudiate, you can even claim for damages. Wow, that means that it must be something that is so, then a condition must be so essential that you can have the right to repudiate. Are you following the line of reasoning? So now the distinction between condition and warranties, though difficult to recognize at times, is illustrated in two cases. The first case is Possard and Spires and Pond. Possard, Possard, Possard versus Spires, Spiers, and Pond, Pond. And also in the case of Bettany and Guy, right? In the case of Possard and versus Spires and Pond, and the case of Bettany and Guy. So those are the two cases that we'll discuss before we go. So we've talked about definition of condition, we've talked about condition precedent, we've talked about condition subsequent, and now we are currently on condition inherent, and we are to discuss the last case before we end our class for today. So when we are talking about the first case of Possard versus Spires, we are trying to show how do we distinguish between a condition and a warranty. Please, what's the time? 52. Okay, very good. So we are trying to distinguish between what a condition and what a warranty, right? We do not know what a condition is and what a warranty is, because the act only tells us the effect. The act does not tell us the nature in such a way that when we look at the clause, which is the what, we can just be able to get that, oh, this one has to do with condition, right? But we are trying to imply from the provisions of section 62 that if section 62 tells us that warranty is what? Is something collateral, then by implication, if warranty is collateral, then by implication it would mean that a condition has to be essential. How do we then argue that? We are arguing the fact that it is essential because for section 11 to have said that a condition, if breached, can lead us to repudiation, then if you can breach a condition and it leads us to repudiate, then it must be something essential, because that same section 11 said that the breach of a warranty only gives you right of damages and not right of repudiation. And then section 62 tells us that that warranty must be collateral. If it is collateral, and then condition according to that 11 is telling us that it gives us the right to what? Gives us the right to repudiate and ask for damages, then it has to be essential. But now that we have looked at the provisions, when you are writing this in your exam, very important for you to look at how I'm dissecting these sections, and this is what you should write in your exam. Very importantly, when you are told to talk on conditions, very, very importantly. And then at the end of the day, especially condition inherent, but like what I've said, and then at the end of the day, you back it up with the two cases I am citing now, Possard versus Spires and Pond and Bethany versus Guy. Let's look at the case of the facts rather of the first case. Now, an actress was engaged to play a leading part in French operetta as from the beginning of its run. As a result of illness, she was unable to take up her role until a week after the performances had started. In the meantime, the producers, who had engaged a substitute to replace her, refused to take her back. She instituted an action for breach of contract. It was held that her failure to appear for the final rehearsal and the early performance of the operetta constituted a breach of condition, and that the defendant were entitled to treat the contract as discharged. Now, I want us to first know, how long was this supposed to go? I don't think it was stated in the fact, but what we know is that for the first week she was not around. Just give me a minute. Okay, yes. I did a little bit of research. You can do yours as well. And then I realized that it was actually for 3 months. She was supposed to, yes, the 14th of June, and an option to re-engage for another 3 months. She was contracted to perform in the capacity for the duration of 3 months. Yes, the contract was for 3 months. I don't think you find this in your textbook. I did a personal research to get this, actually. So I know that when I was reading through, although it's not in my notes because I was trying to make summary of the notes, so I was taking out some irrelevant things and then I took that out. So now we have a singer, right? A singer was contracted. Come and sing in our what is it called? Come and sing in our opera house, our film house, whatever it is. I don't think we have something like that in Nigeria, because what we want to hear in Nigeria is Ashake and Davido. Nobody wants to sit down and be hearing people doing this kind of good. Nobody wants to see that. So what we want to see is dance, leg work and all that. Sure, you get. So now when they contracted her to be to come and sing, for example, let's say they contracted Ashake for a nightclub for 3 months, and then for the first week she didn't come for the final rehearsal, right? That's fine. Then for the first week when she came, for the first week she didn't come as well, right? So after that they had to find a substitute during the final rehearsal and for the next week. That's the first week of the whole show. And then because of that, what did the court hold? They repudiated the contract, right? So the first thing is what happened? What is the clause? The clause is she must come for the 3 months and must perform during the operetta or the opera, whatever, in the operetta. So now for those 3 months, the clause says that she must come and she must perform, right? There has been a breach of that clause because she didn't come for the first week, and then she wants to come for subsequent week, and then they say no, go, we are not going to pay you, and that's the end. And then what is the nature? That's the first thing, because if that clause was a warranty, then they cannot repudiate. They can just ask for damages. Maybe they will say, we are taking 50% of your salary. That's going to serve as damages. Do you understand? But in this case, we have to know what that clause is for us to know the effect of the clause. Do you understand? So if we look at the provisions of section 11 and section 62, 62 tells us mere collateral. Can we say that not coming to perform is only but collateral to the contract? I don't think so. Maybe the person was supposed to wear a particular dress, and then the person, let's say, was supposed to wear a blue dress, and then the person wore a green dress, and then the guy saw him and say, did you react with a blue dress and stuff like that? I'm not giving your money, go. Do you understand? That can be, the dressing could be collateral to the contract, which will you can say, oh, I'll collect damages for not dressing properly. But to say you are repudiating for not dressing, that's going far. But then, don't forget that you're not supposed to put your phone off. But then, talking about this one, where they say she did not even come at all for the first 1 week, that cannot be said to be collateral. So, by implication, what the Sales of Goods Act is telling us is anything that is not collateral is condition. Are you listening to me? Because the Sales of Goods Act did not envisage to us that there is anything called innominate or intermediate. It was Lord Dixon or something, I can't remember his name, in Hong Kong's case. You know, he was the one who brought that. So that's what we are talking about in our next class. The implication of the sales of goods, anything that is not warranty is a condition. Anything that is not collateral is essential. So if we are testing whether or not it is collateral, not to come to perform for 3 months, 1 week you didn't come to perform, that cannot be said to be mere collateral. That is, if it cannot be said to be mere collateral, we cannot jump to the conclusion that is condition. But because there is no other thing for us to say, Abi, the sales of goods that give us any other thing? No. So in the absence of any other thing to say, because it is not mere collateral, then it has to be a condition because it has been breached. Do you understand? We are going to, do you understand the logic? So because we do not know the definition of a condition by the sales of goods, therefore we are using the implied definition of if it's not mere collateral, then it must have been essential. So in the case of Possard versus Spires and Pond, you know, the court held that since it cannot be mere collateral, then it has to be a condition which when breached must, you know, give rights for repudiation, which was what happened. And I want us to look at the case of Bethany and Guy. Bethany and Guy, these two cases in relation to what a condition is as opposed to warranties. You must have them at the back of your head. So in case of Bethany and Guy, the defendant entered into a contract to manage the plaintiff as a singer in opera and concert for a period of 3 months. The plaintiff undertook to be in London at least 6 days before the commencement of his engagement for rehearsals. He, however, only arrived 2 days before the engagement commenced, and the defendant thereupon repudiated the contract. It was held that the term as to rehearsal was a warranty, and whilst the defendant could have sued for damages for the plaintiff's lateness in showing up, he could not repudiate the contract. Can you see what I'm talking about? In Possard, you had a contract. He did not come for rehearsal, but as well did not come for performance for 1 week, and then they had to have a substitute. And then by the time he said he was coming, they said no, we repudiate. But in this case, he was supposed to show up 6 days before, but he showed up 2 days before. So he missed 4 days of rehearsals, but there were still 2 days, and he will still have to perform. They said no, that 4 days that you missed, can we say that is collateral to the contract? Yes. If you look at it from a common sense perspective, it's actually collateral. But for the 4 days that you have missed, I think this is the test. But for the 4 days that you have missed, can we still have the contract in such a way that we want it to be? Do you understand? But for the 4 days, in the case of Possard and Spires, for the 1 week that you have missed, we can't have it the way we want it anymore. Because of your absence, we had to go and hire a substitute. We had to look for a substitute. Do you understand? And the contract which we hired you for was to come and sing. You weren't able to come to sing. But in the other one, he still had the opportunity to sing. The contract was to sing. So what were collateral is that, oh, you are coming to sing for 1 week, for example, but you must be here 6 days before so that you can rehearse. Rehearsal is collateral to the main performance. Do you understand? Rehearsal is what? Is collateral to the main performance. And so if rehearsal is collateral to the main performance, it means that it's a warranty if breached. But if you don't come for the main performance, then that cannot be said to be collateral. That's the main thing now. That's the essential thing. So imagine not coming for the essential thing. Doesn't make any sense. Okay, let me put it to you like this. Now, you have exams. You contracted with somebody, although this is illegal and to not be enforced by the court. But I'm just giving, somebody wants to write exams for 1 week. and then the person told you that, oh, you can come for tutorials 1 week before. Do you understand? Before the exams, right? And then you came for tutorials only 1 day before, and the person said, no, you're not writing the exam for me. But do you get? But you can still write the exams. Do you understand what I'm saying? Now put that as opposed to somebody who did not come for first day, second day, third day, now came for you don't fail the exam already. Do you get? Like, he already has carryover on first day, second day, third day. So this is your fourth day, fifth day, and sixth day that are coming. Now imagine that he now brought somebody as substitute. That substitute did the tutorial and already wrote for first day, second day, third day. You are not coming fourth day, and you're like, but we had a contract, I must write it regardless. Write what regardless? Do you understand? This is an illegal contract. Illegal contracts are not enforced by the court because it's under malpractice. Malpractice is illegal in Nigeria, obviously. But I'm just giving you an example, like if it were to happen. Do you get? So you already have a substitute person that is helping you write the exams. And then the person that comes on the fourth day and is not telling you, no, by force by fire, he must write from fourth to the last day. And do you get? You can repudiate because the main essence of the contract. Now, I don't want to use the word main essence, but I want to say that you can repudiate because the first, second, and third day, they are not mere collateral to the contract. So if you have breached something that is not mere collateral, then there are conditions which gives you right to repudiate. Do you understand? So I want you to juxtapose Bethany and Guy with that of Posad and Spires. So let's go to the last part of my notes, which says that it should be noted that whilst Posad and Spires and Pond, that's the plaintiff, failed to show up for the first 7 days of the actual performance. In Bethany and Guy, the plaintiff failed to show up for the 4 days of rehearsals and the opening of the performance. Hence, the former breach was grave enough to be classified as a breach of condition, while the latter was classified as a breach of warranty. So I hope you understand that. So when we are talking about conditions, we have not been given any definition so far, not by a judge, not by sections, but because we have a section of a section that defines warranty to us as mere collateral, we can by that imply that if something is not a mere collateral, then that thing has to be a condition, not because any judge has told us that is so, but because the act has said it. And if the act says that a mere collateral will be such that will give right to a breach, and the act does not give us any other term of contract, the act only tells us what we are talking about: conditions and warranty, right? It does not give us any other. If he had given us another one, then we still had a debate. Or could it be condition, or could it be the give us the other one? It just gives us one warranty, and then it gives us condition. And it tells us what warranty, what condition is. Do you get? If it tells us that warranty is mere collateral, then we can imply that since condition cannot be mere collateral, then condition has to be something that is good enough to make the contract be repudiated. And with that, you get yourself. Do you understand? So in case there are no questions, please, are there questions so that I can then move on? Are there questions? There are no questions. You people are brilliant students in this class. So first class, no question. Second class, no question. Wow. Very, very brilliant students. So in the absence of any question, we have another class yet today. How many people are in class? How many people are in class? Yeah, we have another class for today, and that class is going to be next 1 hour thereabout. So in the absence of any question, I would like to prepare for that class. Are you sure there are no questions? If you have any questions, please ask them now. I'll just give you about 10 minutes to do that. Sorry, 1 minute to do that. How many hours?
9 minutes.
That's very good. Yeah. Let me see it. So I have a question by Esther Alonge So Esther Longa is saying that can the Sales of Goods Act work for services rather than just goods? Well, like we've said, like the name itself denotes, sales of goods. So no, Sales of Goods Act would not work for services other than goods. It's for goods, so to say. When you get year 3, you are going to learn Sales of Goods Act in first semester. You know, you will learn everything on sales. No, second semester. First semester is on agency and hire purchase. Second semester is that. Now, because the cases mentioned here were not for sales of goods but rather services, can you explain condition inherent again? I think I already explained condition inherent very well, you know. But let me just give you another exposition. Tell me if there are any other questions. I think I already explained condition. The essence of explaining Poussard and Spears, Poussard versus Spears and Pond, and the case of Bettany and Guile is to explain condition inherent. But let's take it one more time. So I already told you that when you are talking about condition precedent, a condition which must be done before a contract can come, a condition subsequent, a condition which after we have made an agreement, then the condition came after and all that. But when you are talking about a condition inherent, it is in the contract. Do you understand? It is something that is inherent in the contract. So we have a contract for sale of let's say sale. My this thing is getting finished. So we have a contract for sale of car, right? Contract for sale of car. A condition inherent would be that I want you, it would be a car. Do you understand? It's a condition inherent in the contract that you should give me a car. It's a condition inherent if you make it so. It's a condition in the contract that you should deliver my car or so day. That's inherent. It's not something that should be done before this contract comes into play. No, a condition precedent is done before a contract comes into play. A condition inherent is the condition in the contract. I want a phone, right? So what I will expect you to give to me is a phone, not to give me something else. And then I can begin to tell you conditions relating to that phone that I want. So if I want the phone to have the ability to call and do every normal thing, that's a condition inherent in the contract. Do you understand? No condition previous, that's preceding the contract, condition precedent, or condition that comes after the contract, condition that comes in the contract. That's condition precedent. So for example, when you are talking about Poussard and this thing, I told you to come and perform, right, for 3 months, and then you did not come for 1 week. It is a condition inherent in the contract that you are supposed to perform. For me, that is the essence of our contract. It is inherent in the contract. It's the essence of the contract. So if you did not come for 1 week and it's a condition inherent, then I can repudiate. Do you understand? That's what the court is saying. So when you're talking about condition inherent, the condition that is in the contract. Is there any other question? Can you please explain the issue of mere collateral? Someone said, can you explain if it does not, why are we using it to refer to cases where services were rendered other than goods? I will have to look at those cases where services, I think, who is asking this question? Esther Longe. I have to look at those cases where services were rendered other than good under the Sales of Goods Act separately. Maybe you would have to message me for that one for me to look through it. But somebody said I should explain condition inherent again, and I already did that. But someone said I should do something. I can't remember. Yeah, mere collateral. What did you say? Yeah, mere collateral. So I'm supposed to explain mere collateral. I think I already explained that when I was talking about warranty. And I said that when you are talking about warranties, section 62 says is mere collateral to the contract. Mere collateral means that it is not something that is so essential to the contract. Now let's look at Bettany and Guy, for example. You are supposed to write exam. You are supposed to come and perform. So your performance was from Monday to Friday. This is the contract. Are you listening? Come and perform for me from Monday to Friday. You did not come, and then not part of the contract also says that before this Monday to Friday, oh, you should also come Tuesday to Sunday before this Monday to Friday. Come Tuesday to Sunday, very important. But the contract was for Monday to Friday of the following week. You should know that I'm talking about 2 weeks here. So the following week, come, you have a show for Monday to Friday. But for Tuesday, previous week, the Tuesday to Sunday, you are supposed to come and do rehearsals. He didn't come on Tuesday. He didn't come on Wednesday. He didn't come on Thursday. He didn't come on Friday. He came on Saturday. And then because he came on Saturday, you then said, oh yeah, be going. You did not come Monday, Tuesday, Wednesday, Thursday, Friday. So the question is, I told you that when you want to look at the contract, look at the words. The question is, can this be said to be a condition such that a breach of it would be said to, the person can repudiate and say no? The first question you need to ask, what is the main essence of the contract? The main thing in this contract, come and perform Monday to Friday. That's the main thing in the contract, right? So a breach of anything that has to do with the performance from Monday to Friday would be something that would be regarded as a condition. This one, come and do rehearsals, cannot be regarded as, so essential to this. It's collateral to it, something that when you breach, you can claim for damages, not that you would then say that you want to repudiate. That's why I gave another example. Is there something wrong? That's why I gave another example of, imagine that the person actually came for the whole rehearsals, and then the person came here and he was performing, and then instead of the person to wear a blue cloth, the person wore a green cloth. Can that be said to be so intrinsic as to stop the person from performing? No. It's collateral to the contract. Do you understand? It does not shake the essence of the contract in any way. What is the contract? Come and perform. When you don't come for rehearsals, 4 days for rehearsals out of 6 days thereabout, does that stop you from performing? It's collateral to the performance. Do you understand? But when you are performing, now let's say you came for this or whatever. Now when you are performing, they said wear green or wear blue, you wore green. Does that stop you from performing? Does that affect your voice? Does that affect your dance step? No. Now, has it stopped you from performing? No. So the other party can institute an action to collect damages for that, but it does not stop the contract in itself. When it doesn't stop the contract, it doesn't operate to stop the contract, that would be a warranty. If it does not operate to stop the contract, it will be a warranty. So when somebody, they contracted you to come on Monday to Friday, you didn't come Monday, you didn't come Tuesday, you didn't come Wednesday, then I came Thursday, hasn't it stopped the contract? The contract was come on Monday. Did you do it on Monday? He stopped it then now. He stopped it on Tuesday. He stopped it on Wednesday. So you can repudiate. But when you don't come here, does it stop the contract here? No. Do you understand? This is merely collateral to this. The dressing is merely collateral to this. Collateral means that they are not in the essence of singing. It is merely collateral. Do you understand? So sorry, 1 minute. So if you're having let's say Monday to Friday, like I gave there, so you are supposed to come Tuesday to Sunday, rehearsals, abi. This is collateral. If you are supposed to wear green, you wore blue. This is collateral. If you are supposed to what else could you have done? Maybe you are supposed to dance with the dancers of the organizers, but no, you brought your own dancers. That's another collateral, because it does not stop the main contract of dancing. They say they want their own organizers dancers. You say you want your own and you brought your own to come and dance. That is, or let's say they say they want your own, you said you don't have. That is, it cannot operate to destroy the whole contract. They are collateral. What you should look at is, does it stop the contract from happening? If it stops, then it cannot be said to be collateral. Do you understand? Then it has to be a condition. So is there any other question? So yeah, if we don't have any other question, we are going to a more difficult part. This judge in Hong Kong case now decided, you see how this thing is easy like this. Oh, we know what is warranty and what is collateral, right? Okay, then just wait till where the Hong Kong guy, the judge in the Hong Kong case, that's Kawasaki Kisen, now said, yes, no, everybody, you have too much of peace of mind. I want to take away that peace of mind from you and decide to introduce a new term known as innominate or intermediate term, where we now go to look at what is the substantial benefit test. So the nature, if it's an innominate this thing, they will now look at the effect. The effect is under substantial benefit and all that. So you see, that one is even more complicated class. This one is still straightforward. We've gone through condition, blah blah blah. We are done with this, right? Good. Now we now have another class where we talk about innominate, yes, innominate and intermediate term and all that. That's going to be our penultimate class for today. You know, after that we have a last class of what are fundamental test lecture, and I hope I've been able to explain, you know, what a condition is, what warranty is, and condition precedent, subsequent and inherent, the one before, the one after, and stuff like that. So I just hope that you enjoyed the class and you get the whole thing. I will see you in my next class. Thank you so much.